Boom! That song kicks ass. I love that opening song for these murder churches for Aileen Wuornos. Welcome everybody. Hit the like. Give it a share. Yeah, let's hang out. Let's rock and roll. Thanks everyone for coming in. Hit the like. Give a share. We're going to be finishing up closing arguments. We didn't get all the way through those last week. We're going to be finishing those up and see how far we get today as we get closer to a verdict for Aileen Wuornos from 1992, I believe this trial is from. Let's go. Let's fuck.
I get my hair out of my face while I'm doing this.
Let's rock.
Let's rock, says Al Bundy. What's up, everybody? Good morning. We've made it through the winter storm here. We still are under a warning till tomorrow at 1. We did get quite a bit. The wind was absolutely insane. It looks like we did get some ice and snow, and I currently can't leave the house. I live in an area that's kind of down in a valley, I guess. I don't know what you would say. And yeah, if we get a lot of snow, I am trapped, and we have to wait for a truck to run. So hopefully they'll be scraping. I say they won't even scrape here on Sunday, so I will probably be trapped today, which is fine. I've already got a lot of stuff, and I don't really mind, but hope everybody else is good. Hope everybody else is well. Yeah, I believe I've got the right spot here. Actually, I'm not sure at all. I just kind of guessed. I knew we had about an hour left of this from last Sunday, so we're just going to kind of pick up here where they're still doing the closing statements. But yeah, welcome everybody. What's going on? Let me see if I can get the fine folks in here so we can chat. See who we got. First of all, Murder Church bells. Hold on. What's up, Gary? We have at least 7 to 8 inches here, and it'll snow until tomorrow. Yeah, that's what I'm worried about, honestly. Yo, Tayo, Phil, what's up, dude? Hope you're well. Hope you didn't get slammed as like everybody else seems to have. It seems like it got everybody. This time is what's crazy. Sharon coming through. What's up, Sharon? Welcome in. Brooklyn in the house. Mike's coming through. Sleuthy Sweetheart, who I saw, she's in Texas, and she posted a picture in Discord of what she's looking at, which doesn't look good either. Texas got hit. Everybody got hit. Simi's in the house. Again, everybody's having or had a great weekend. Who am I missing? I think I got everybody. Well, Jesse Charles showing off a badge here. Member for 24 months, 2 blazing years. Love y'all. Thank you so much for that. That's incredible. That's amazing.
I'm telling you like it is, baby.
Love it.
Happy anniversary. Happy anniversary.
Happy anniversary. Bassett Page, what's up? Oh, Bassett Page, hope you're doing well also. I think I got everybody. I know there's probably a lot of people who's coming through here. Teresa, good morning. Those coming through here. Real Government Name was coming through here this morning. And so I've started a new, Leia, what's up? Get in here. The bells have returned. So I've started a new show on Saturday night for Wrestle Plunge exclusively on Twitch. I'm doing the shows over there. We had a good time last night. They don't start till 10 at night, and we go into midnight. And then after that, usually after a show, I have to wind down. So there's a possibility that the Sunday morning show will be moved to 10. Maybe. It might fit better if I started at 10. So we're going to see. I'm going to play with it. Well, I'm not officially doing that just yet because I like to get the earlier start at 9, and then we can really get into sometimes 2.5, 3 hours if we really need to, if I'm starting to feel it. But it is what it is. And either way, we'll be here. We'll be doing a damn thing, even if we get an extra hour of sleep. So we'll see. I'm not doing that officially yet. I'll say that. Yeah, 21 feels like 5. That sounds like about what it was here. Oh yeah, an art class. Yeah, anybody that wasn't here yesterday, I had art with Viv on here, and it was super fun. She taught us how to paint. She painted live for us, and that is still up for everyone to check out in the video in the live section. It's for everybody. I didn't put that as a members. In the future, those might become member only streams because those are pretty special. But I did want to get one out there for everybody to see. Everybody kind of get the vibe of what Viv is like, and make sure you're following Viv on YouTube. And then again, she has a Patreon that she does a lot of exclusive content on, and then she has a free version of Patreon as well. She was talking about. So make sure you're following Viv. Viv is an awesome lady, really true, kind soul. She feeds 17 raccoons. She feeds a lot of possums. She's basically got a Disney movie at her house is what's going on. And a beautiful dog named Darcy. She's a great lady. You have to check it out. It's really good. And literally, if you get the supplies that, we're in the emails, and if you get her in the Discord, there's no way you can miss. You'll be able to plant exactly what she showed us. So it's 12 degrees in Texas. That is crazy to hear for Texas. That is absolutely insane. Yeah, I bet nobody's doing anything in Texas. Like, that's one of those spots like South Carolina or Florida. If you guys get some ice, it's shut. Like here, honestly, we get it so often. It's pretty regular thing. I'm not like I'm leaving today, but the trucks will come out. They'll ice. Drop salt. More than likely, I will be at work tomorrow unless it just continues to just pound us, which I'm hoping it doesn't. But all right, without further ado, let's get in here. Holy shit! Hold on. Let me see what I'm doing here, because I don't actually know what I'm doing. All over the place sometimes. I'm all over the place. Let's just get out here. Let's get her going. One thing I want to do is move this right here. And I want to move this. I want to make this a bit bigger. Yeah. Let's go, guys. Let me get the sound in here. Still set up for last night. Now, this is roughly where we are. We may have already watched this, but it's in the ballpark, so bear with me.
And she told me, why would Ty Moore come in here, as Ms. Wuornos said, in lie? They were very close. They were good friends. They were lovers. Close as peas in a pod. Close as a knot. Heard all of those descriptions by Ms. Wuornos and not denied by Ty Moore. Ms. Wuornos says because she knew it was self-defense and she might be in trouble if she told it was self-defense. Now, how would that cause trouble? If anything, it might give some moral justification to the fact that Ty Moore didn't come forward and tell about this killing. that she believed her girlfriend was raped and brutalized, and therefore, because of horrible things done to her, she didn't tell anybody. Because the guy deserved to die anyway, and we're just not going to tell anybody. We killed the rapist. She killed the rapist. And we know about it.
Damn, 3.
That would
Let's see
be
what it is.
the
I'm going
most
to
logical
look for
story
official
if, in fact, it was true.
weather here.
But it wasn't true. It was not true, because it is not true, because she never told Ty Moore that. What she told Ty Moore, and told her several times just before the news came on, as she was drinking, Ms. Wuornos.
So we got 19 feels like 7 here. I wonder if we're still under that winter weather advisory. Still calling for stuff through the day, so it looks like tomorrow they're calling for shit too. Leave my family alone.
And she knew that this car she'd been driving around in that day was suddenly going to be on television because there was now a body. You know, simply an abandoned car doesn't make the news. An abandoned car linked to an abandoned rotting body makes the news 2 weeks later. 2 weeks later, she realized, uh-oh, Ty knows I have this car.
Oh yeah, the fucking ice here.
Ty really didn't borrow this guy's car. I found a body in the woods, where she started off. Found a body in the woods. And then Ty said, what are you talking about? And she used some profanity, got loose talk they use among themselves. And finally she said, well, I had to kill this guy. What? You're blanking me? Come on, you're kidding. No, I had to kill this guy. And that's it. Or I killed this guy. She didn't use the word I had to kill this guy. I killed this guy. And that was it. That was the whole story. This is her best friend, roommates, sweethearts, companions. Doesn't tell her anything. That is incredulous. You don't need a expert, the way of a pathologist, and want to tell you what common sense tells you. In fact, if it was for the story, now the other reason Ms. Wuornos gives us is, well, it was a story. She wanted a story. She's going to make, gosh, I don't know, it sounded like $5 million or $500,000. Either one's a lot of money. She's going to make a lot of money by lying about this self-defense thing. Well, that's just not true, is it?
Lying about
Wouldn't
this
it be a
self-defense
much more
thing.
interesting story and a much more sellable story
I need to go make some coffee too.
if this poor,
After this right here, huh?
pitiful prostitute
Start this day really right.
Simply
You hear what I'm
do her
saying?
job.
Listen to this.
and some guy did some horrible things to her, and she killed him in self-defense. Now that's a good story. Got one that's even better. And then her girlfriend, who knew all about it, got on the stand and told the jury how it was self-defense and how when Aileen came in, she had bruises on her neck and hardly talked because the rope had almost choked her, and had been beaten brutally, and that she ministered to her private parts of her body because they were torn, and there was blood in her clothes and her underwear, and that this was a terrible thing.
I'm gonna make some ice. I'm listening. Be right back. Some ice. I'm gonna go make some coffee.
The state of Florida tried to convict her. And a good, reasonable jury saved her. That's a good story. That would sell a lot of books and movies. And would be a gross injustice. The attack upon Deputy Horzepa, who is not responsible for what items are or not presented in evidence. The prosecution is responsible, along with the defense, ruled upon by the court, as to what you receive in evidence. Deputy Horzepa has done nothing except sit here and testify under oath like any other witness and tell you what he did and what he had. She says she was cut off continuously, couldn't finish her statement. Her lawyer was sitting there. Would any lawyer allow the police to cut off his client so she couldn't tell her story if she had a story to tell? In 3 hours and some odd minutes, you only have about 25 minutes of it, though. Is there one shred of evidence or testimony by her where she says that she was tied up even tied up? How about just stopping there? I thought the story was going to be a coat hanger tied her up. I thought they were going to say that she was tied up with a coat hanger. Remember all the big issue about was there a coat hanger, was there a straight coat hanger? And I didn't know, and we don't know where they're going. We just have to wait and hear it when it hits the stand, same as you. So we spent, I guess, half hour on coat hanger. It didn't mean anything. In fact, we also didn't find any electrical wire, didn't find any rope. Abandoned in either place. Found the evidences of some drinking, perhaps some partying. She was told to tell it all. She was told you have an opportunity to tell everything. She did tell us something. She said what she deserved. But she never told anything about a rape. She mentioned the word rape a couple of times. Spread out over 7 stories of men. She never said that Mr. Mallory raped her. Certainly never said that he tied her to a steering wheel. In fact, if you recall, I asked her about this anal rape thing, and she said, no, that's a different one. That's a different man. Different one. Doesn't count. Can't talk about it. In fact, she's told you that virtually everyone in the courtroom has lied. Even Bobby Copas. Remember Mr. Copas? Looked like a trucker. I guess truckers are pretty big guys. I'm sure there's some skinny truckers out there, but most truckers look big, at least in the movies and on this witness stand in this case. Even Mr. Copas, she says, is a liar. And I don't like to use that word, but that's what she said. Because he wants publicity. Well, did Richard Mallory give her money in advance? And then was she afraid he wanted to take it back, as she said in her first statement? Or was he just a nice guy and she decided she could trust him and wasn't worried about the money until they got to argue about unzipping his pants, as she said in the second story? Had she had the gun 2 months or 2 days? Well, she corrected herself. She's the one that narrowed it down to 2 days. She's, oh, wait a minute, went back to that herself. It wasn't on prompting from anyone else. That's why we accepted that as the best version. Pretty good evidence. Because it was only a couple days after she said she got the gun the killings began. Something about having a gun that changes some people. And maybe it's a good thing we don't let convicted felons have guns, despite her view to the contrary. She was pretty astute on the stand, and certainly 2 hours on the stand or so would not be easy for anyone. But she was able to correct me on what pages in the transcript certain matters were. Oh no, that's on page 9. You better look over on page 53. I said, well, we haven't got there yet. We'll get there in a few minutes. Asked her about the trajectory of the bullet. Remember Dr. Body talked about the trajectory of the bullet? She said, oh, I thought the body was too decomposed for anybody to tell the trajectory of the bullet. She wasn't missing a lick. She knows what she's doing. And she has carried her pattern of manipulation into the courtroom to try to manipulate your verdict. She told you that she was threatened with the arrest and persecution and prosecution of Ty Moore. And that's the only reason she said all these things. I think got a clear choice there. Either Deputy Warzeppa is flat, sitting here and not telling you the truth, or she's not. There's no gray area there. Someone of the two is not telling you the truth. fact, she told us in her testimony, she said, "I'm the only one telling the truth. Everybody else is lying." I think she said, except me and my lawyers. But everyone else is lying. To convict an innocent person? She told Ty Moore just enough that Ty wouldn't flip out when she saw the car on the television she'd been riding around in 2 weeks earlier. And she didn't tell her anything else. Ty Moore should have come to the police. Ty Moore should have reported it. And maybe, just maybe, it would have stopped right here. Ty Moore is going to have to live with that. Ty Moore is not on trial. This is a murder trial for Aileen Wuornos. That's where it should have ended. This is because people don't want to get involved. And goodness knows, you've seen some witnesses here, you see why they don't want to get involved. But we've got to be involved. You've got to be involved. The system isn't going to work if we hide behind our privacy and our fears and our private lives. Ty Moore refusal to either believe or accept and believe and then to tell anyone could have saved 6 men's lives. And that doesn't hold her up for anything respectful or honorable at all. By the same token, if she'd been told this was a brutal anal rape, etc., it would have at least given her some moral justification for not saying anything. And she knows that. And she would have said that if it was true. Because it's not true, she didn't say it. It was bad enough that she didn't come forward. At least she didn't sit on that witness stand and lie to you to perpetuate and protect this woman who killed Mr. Mountain. We heard a lot from her. This is a murder out of greed. This is a woman that can make, according to her own testimony, I don't care how you figure it, $30,000 to $50,000 a year and squander it just as quickly. This is a woman moving out of power and control into a new and unfathomable for you and I area of domination to the extent of snuffing out life. It became obscenely simple to have it all.
I'm back.
Is there any answer to the whys and how did this happen? Not for this jury, not for this time, and not for us. She chose her life. She chose the time and the place. And she has left you no reasonable choice. No reasonable choice under the evidence of this case. Except to find her guilty of murder in the first degree and armed robbery. Thank you very much.
Morning, Sarah.
Thank you, Ron.
Forgive me if I'm a little disjointed in my final remarks to you, members of the jury. I have a lot of things to respond to based on what you just heard. I would start out by agreeing with Mr. Tanner about one thing, and that is that your service is vital in this case and is an exceedingly important job. Take it seriously and think about everything that you have heard. And when you're doing that, demand of Mr. Tanner proof, not speculation. Demand of Mr. Tanner evidence. Mr. Tanner just talked about, well, maybe he was like this, or maybe he was lying down. Maybe a straight shot means he was lying down. Well, maybe a straight shot means that this man was coming right at this woman. And maybe a straight shot means he was right on top of her. How did the shot get in the arm? Think about it. Some man's coming into a car to get a woman. Maybe that's how it happened. But maybes don't cut it in court of law. Maybes don't work. Perhaps doesn't work. The burden is on the state, and the state has given you nothing. Demand more. Mr. Tanner speculates, well, you know, Ty would have been on high moral ground if she'd have come in here and said something about being told that Lee was anally raped by Mr. Mallory. What better reason for Ty Moore not to go to the police when she was first told about it? Lee Wuornos told you that she told Ty Moore why this thing had happened, and there's no better evidence than what Mr. Tanner pointed out to you. Mr. Tanner spoke some about the robbery charge in this case. When you listen carefully to the robbery instruction, and you listen to whether or not there was any evidence that Lee Wuornos threatened anybody or killed anybody or did anything to get property. Is Lee Wuornos guilty of theft? Sure. Find her guilty of theft. She should not have taken that property. I suggest to you, you don't have to find her guilty of theft, that her actions and her state of mind were such that that can be excused. But there's no legal justification for finding her guilty of robbery. I also agree with Mr. Tanner about another thing, and that is that we don't want you relying on sympathy. I'm not asking you to feel sorry for Lee Wuornos. She doesn't need your sympathy. She needs fairness. She needs justice. She needs you to understand what really happened in December of 1989, and she needs you to return a fair verdict. She needs you to interpret exactly what the evidence that came from that stand has told you. And that is that she had every right to shoot Mr. Mallory. She had every right to shoot him not once, not twice, not three, but 4 times. She was terrified. She was drunk. She was naked. She was tortured. And she defended herself. That's not a crime. Don't ask you for sympathy.
I don't know.
The
Did we
law
figure this out?
says
I almost
she's
feel like
not
somebody
guilty.
did, but I'm not sure.
Mr. Tanner also got up here and he spoke to you about the fact that Aileen Wuornos is a prostitute. Aileen Wuornos asked to be a prostitute. Well, did Aileen Wuornos ask to be slapped?
Come on down!
Did she ask to be tied to a steering wheel? Did she ask to be anally assaulted? Each and every one of you in jury selection indicated that you could be fair. Each and every one of you indicated that a prostitute, yes, a prostitute can be raped.
This guy didn't do
Mr.
too
Tanner
hard last
suggests
week,
to you
right?
that somehow she brought this all on herself because of her profession. She was raped, and she was brutalized. And despite her profession, she had a right to defend herself. Mr. Tanner quarrels with Ms. Jenkins' opening statement. He says, well, what was she hiding from? Well, I believe if you listened carefully, the opening statement was that Ms. Wuornos was underneath the culvert because it was raining and it was dark. And when this car backed up, that in fact she was worried about who might be inside. And that's exactly what she told you from the witness stand. Then Mr. Tanner went on to say, well, Lee told you that she had told Ty what had happened back in December of 1989, and that she had told Ty that it was self-defense, but everyone else said something different. Where's the everyone else? You got Tyra Moore, and you got Aileen Wuornos. What do you mean, everyone else? And what are Ty's motivations?
Terrible.
Mr. Tanner asks you, why would Ty lie? Don't forget who her friends are in this case. Mr. Tanner suggests, well, self-defense would make a whole lot better book, a whole lot better movie. Yeah, except the person who told her about the $50,000 and the book and movie deals was a law enforcement officer. Her best buddies, Rose G. and Sonny,
That's right.
of the Florida Department of Law Enforcement. But what are her motivations to come in here and say something to convict Lee Wuornos? You be the judge. Mr. Tanner talks a lot about prostitutes and control and taking the man for everything he has. Have you heard one single shred of evidence that talks to you about what prostitutes think? Have you heard an expert come in here and say they can read prostitutes' mind? What did Lee tell you about prostitution? About the numerous times she was beaten, about the fact that her lover didn't even want to hear about it. Her lover who was more than willing to take her money, but didn't want to hear about
Oh my
it.
God.
Mr. Tanner quotes Lee and says, well, I told her that I killed this man, speaking of what she had said to Ty. And Ty's response was, you're blanking me. I don't believe this. That's what Lee said in 1991. And why did she say that? It's obvious. The whole reason she was there was to clear Ty. What's she gonna say? I told her all about it, and she believed me, but she didn't do anything. And Lee told you that from the stand, and that's why she made those comments as well. She told you that. The fact of
Never
the
mind,
matter.
hearts on the side. I can even hit that flying hearts. I'm banging them things right now, just banging them.
Is Ty Moore told you that her response to Lee was not, you're blanking me. Ty Moore told you 2 weeks ago, my response was, I didn't want to hear about it. And that's what really happened. When you look at the evidence in this case, look carefully at this photograph of Mr. Mallory's vehicle. You heard Lee Wuornos talk about a rape. And you heard how she said she was tied to the steering wheel. You look at the steering wheel when you get a chance. Look at it carefully. Look at the condition of the steering wheel and ask yourselves, is that consistent with what Lee told me from that stand? It is. It is. Then Mr. Tanner said something that was almost humorous. He said, well, if Lee was getting cut off, she had her lawyer there. How come her lawyer didn't do anything? Watch the tape. Listen to that lawyer. First of all, it's enormously difficult to understand a word he says because his accent is so thick. Second of all, she'd never met the man before in his life. Third of all, he didn't say a word other than making a blanket statement to cover himself that, well, I kind of talked to her about the fact that she doesn't have to testify. And more importantly, he left in the middle of the interview. Mr. Tanner spent a lot of time talking about Mr. Botting, And then he speculated as to what the sequence must have been based on all these things and principles. What did Dr. Botting tell you? This is his expert. This is what he put on the stand to teach you what happened. He said, I don't know what sequence. I don't know where they were positioned. I can't say what they were doing. And again, he certainly said, I can't tell what was happening before the shots were fired. The state has given you nothing to show anything except self-defense in this case. Nothing. Mr. Tanner, in essence, is arguing to you that you have to convict Lee Wuornos. You have to convict her based on what she did not say at certain times. The fact of the matter is, you must acquit Lee Wuornos because of what she did say, both in January 1991 and here in this courtroom. And when you consider the Mr. Spears, the Mr. Cascade, and the other things that Mr. Tanner talked to you about, he suggested that I somehow argued that it wasn't admissible. Of course, those items are admissible. You saw them. If they weren't admissible, they wouldn't be here. What I suggest to you is they are meaningless in this case. And they are for other juries. And they are for other judges. Because what Mr. Tanner did not explain to you when he went through the dates on these things is that, yes, Richard Mallory was killed in December of 1989. David Spears died in June of 1990, 6 months later. The things that happened after Lee Wuornos went through the hell that she went through in December of 1989 are not indicative of what she was thinking at that time. It's not logical to assume that her behavior 6 months later had anything to do with whether or not she was being savagely raped. If anything, her rape explains any future behavior.
Right? Somebody's mentioned that earlier. Did they get in trouble?
You didn't hear anything about anyone in November of 1989 or October of 1989 or September of 1989 or September of 1988 or 87 or 85 or 75. No, it wasn't until Richard Mallory did what he did that Lee Wuornos responded.
Direct now. Welcome in, everybody. Thanks for coming in.
The evidence is clear that she had every right to do that. You're about to go into that room. You're going to be instructed on the law first. And when you go back there, demand proof from the state, not speculation. Consider what you've heard from that witness stand. Consider Larry Orzeva and Tyra Moore for what they are. And consider whether or not Bobby Lee Copus is telling you the truth. And consider how many times Lee Wuornos cried out. She responded in self-defense in this case.
If that is the only black person, that's awkward as fuck. They're like, yeah, how about you sit outside? He's like, really? Fucking really, guys?
When you do that, and you assimilate all that you've heard over the last 2 weeks, there's only one verdict you can return. And that verdict is not guilty to each and every count.
Maybe he's is he the dude that watches the juror, like the cop? But normally, no, they're usually dressed pretty nice. They're not usually in a uniform. No, he's wearing the yellow badge. Never mind. And there was the foreman, the cop. God. So right now we're going to verdict, which we still have a lot more after the verdict for anybody that was watching last week. There's a penalty phase here in Florida. There's a penalty phase in West Virginia as well that I've learned recently because I was a part of one here with the murder trial. So yeah, there's a penalty phase after this, so which is already we already know what's happening. My God, we're just watching this because we want to see all the details. But
Aileen Carol Wuornos, also known as Susan Lynn Krapluck, also known as Laurie Kristen Brody, also known as Jenny Marsh Green, heretofore referred to as Aileen Wuornos. The defendant in this case has been accused of the following crimes. Count 1, murder in the first degree, and count 2, armed robbery. Murder in the first degree includes the lesser crimes of murder in the second degree, murder in the third degree, and manslaughter, all of which are unlawful. Killing that is excusable or was committed by the use of justifiable deadly force is lawful.
But the alternate, I don't think, would have been dismissed just yet, so maybe.
If you find Richard Mallory was killed by Aileen Wuornos, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the first degree, or was murder in the second degree, or murder in the third degree, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in the dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under the following circumstances. 1, the killing is committed by accident, misfortune, in doing any lawful act by lawful means with usual ordinary caution and without an unlawful intent, or 2, when the killing occurs by accident or misfortune in the heat of passion upon any sudden or sufficient provocation, or 3, when the killing results from a sudden combat without any dangerous weapon being used and not done in a cruel and unusual manner. I now instruct you on the circumstances that must be proved before Aileen Wuornos may be found guilty of murder in the first degree for the death of Richard Mallory or any lesser included crime. There are 2 ways in which a person may be convicted of felony murder. One is known as premeditated murder, and the other is known as felony murder. Before you can find the defendant guilty of first-degree premeditated murder as charged in count 1 of the indictment, the state must prove the following 3 elements to be known under reasonable doubt. 1, that Richard Mallory is dead. 2, the death was caused by the criminal act or agency of Aileen Wuornos. And 3, that there was a premeditated killing of Richard Mallory. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the accused. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing.
It's the same person.
The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. There will be sufficient proof of premeditation if the circumstance of killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find Aileen Wuornos committed first-degree murder, you also find that during the commission of the crime she used a firearm, you should find her guilty of first-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a riot.
Ears are the same. Hair is the same. If he had glasses, it would be uncanny. Body shape's the same. Double chin's the same.
Or encouraging of a riot,
Pretty
or the
crazy.
commission of a murder, an armed robbery, an aggravated assault, an aggravated battery, a burglary, an aircraft piracy, a kidnapping, or a sexual battery. If you find that the defendant committed a first-degree murder but did not use a firearm, then you find her guilty only of first-degree murder. In count 1 of the indictment, before you can find the defendant guilty of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. One, that Richard Mallory is dead. Two, the death occurred as a consequence of, and while Aileen Wuornos was engaged in the commission of or attempting to commit robbery, for which will be subsequently defined to you. Aileen Wuornos was the person who actually killed Richard Mallory. In order to convict the first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. If you find that Aileen Wuornos committed first-degree felony murder, you also find that during the commission of the crime she used a firearm, you should find her guilty of first-degree felony murder with a firearm. A firearm was previously defined in these instructions. If you find only that the defendant committed first-degree felony murder but did not use a firearm, then you should find her guilty only of first-degree felony murder. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime for which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes indicated the definition of premeditated murder. In count one is first-degree murder, murder of the first degree, and first-degree felony murder. And then the lesser included offenses are murder.
Yeah, through the whole trial, it's basically been pretty difficult to understand the judge at portions. I can understand this pretty well.
The second degree, murder, the third degree, and manslaughter. As to count two, the lesser included crimes indicated the definition of armed robbery with a firearm are with or without a firearm, with or without a weapon, grand theft, and petty theft. Count one of the indictment, before you can find the defendant guilty of the lesser included crime of second-degree murder and the death of Richard Mallory, the state must prove the following elements beyond a reasonable doubt. One, that Richard Mallory is dead. Two, the death was caused by the criminal act or agency of Aileen Wuornos. And three, there was an unlawful killing of Richard Mallory by an act eminently dangerous to another and affixing a depraved mind regardless of human life. An act is one eminently dangerous to another and affixing a depraved mind regardless of human life. It is an act or a series of acts that one, a person of ordinary judgment, would know is reasonably certain to kill or to do serious bodily injury to another, and two, is done from ill will, hatred, spite, or evil intent, and three, is in such a nature that the act itself indicates an indifference to human life. If you find that Aileen Wuornos committed second-degree murder, you also find that the commission of the crime she used a firearm, you shall find her guilty of second-degree murder with a firearm. A firearm has previously been defined for you. If you find only that the defendant committed second-degree murder but did not use a firearm, you should find her guilty only of second-degree murder. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had a premeditated intent to cause death. In count one of the indictment, before you can find the defendant guilty of the lesser included crime of third-degree murder, the state must prove the following elements beyond a reasonable doubt. One, that Richard Mallory is dead. Two, the death occurred as a consequence of and while Aileen Wuornos was engaged in the commission of grand theft. And three, that Aileen Wuornos was the person who actually killed Richard Mallory. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. Grand theft will be defined for you later in these instructions. If you find that Aileen Wuornos committed third-degree murder, and you also find that during the commission of the crime she carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of third-degree murder with a firearm. A firearm has previously been defined for you. If you find only that the defendant committed but did not carry, display, use, threaten, use, or attempt to use a firearm, then you can find her guilty only of third-degree murder. Count one of the indictment, before you can find the defendant
Not great.
guilty of lesser included crime of manslaughter.
You really get the hang on that double chin from this view.
The statements prove the following two elements beyond reasonable doubt.
As a man with a double
One,
chin.
that Richard Mallory is dead. And two, the death was caused by the act, procurement, or culpable negligence of Aileen Wuornos. However, the defendant cannot be guilty of manslaughter if the killing was either justifiable or excusable homicide. To procure means to persuade, induce, prevail upon, or cause a person to do something. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, which shows wantonness or recklessness or grossly careless disregard of the safety and welfare of the public, or such indifference to the rights of others as is equivalent to intentional violation of such rights. Negligent acts or omissions must have been committed with an utter disregard for the safety of others. Culpable negligence is conscientiously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. If you find that Aileen Wuornos committed manslaughter, and you also find that during the commission of the crime she carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm has been defined for you. If you find only that the defendant committed but did not carry, display, use, threaten to use, or attempt to use a firearm, then you should find her guilty only of manslaughter. An issue in this case is whether the killing of Richard Mallory was excusable. The killing of a human being is excusable and therefore lawful if committed by accident and misfortune. In order to find the killing was committed by accident and misfortune, you must find the defendant was 1. Doing a lawful act by lawful means with usual care and acting without any unlawful intent. 2. In the heat of passion brought on by a sudden provocation sufficient to produce in the mind of an ordinary person the highest degree of anger, or rage, or resentment that is so intense as to overcome the use of ordinary judgment, thereby rendering a normal person incapable of reflection. And 3, engaged in sudden
Put this in
combat.
Discord.
However,
Son,
the killing
you,
that occurred through sudden
Judge
combat
Chan.
cannot be excusable if a dangerous weapon was used or the killing was done in a cruel and unusual manner. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce a death or a great bodily harm. An issue in this case is whether the defendant Aileen Wuornos acted in self-defense. It is a defense. It is a defense of the offense in which Aileen Wuornos is charged with the death of Richard Mallory resulted from the justifiable use of force likely to cause death or great bodily harm. The use of force likely to cause death or great bodily harm is justifiable only if the defendant reasonably believes that the force is necessary to prevent imminent death or great bodily harm to herself while resisting another's attempt to murder her, or an attempt to commit sexual battery, aggravated battery, or aggravated assault upon her. A person is justified in using force likely to cause death or great bodily harm if she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to herself, or the imminent commission of sexual battery, aggravated battery, or aggravated assault against herself. Sexual battery, aggravated battery, or aggravated assault will be defined for you later in these instructions. However, the use of force likely to cause death or great bodily harm is not justifiable if you find 1, that Aileen Wuornos was attempting to committing are committing or escaping after the commission of robbery. Or 2, Aileen Wuornos initially provoked the use of force against herself unless the force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and exhausted every reasonable means to escape the danger other than using force likely to cause death or great bodily harm to Richard Mallory. In good faith, the defendant withdrew from the physical contact with Richard Mallory and indicated clearly to Richard Mallory that she wanted to withdraw and stop the use of force likely to cause death or great bodily harm, but Richard Mallory continued to resume the use of force. In deciding whether the defendant was justified in the use of force likely to cause death or great bodily harm, you must judge her by the circumstances by which she was surrounded at the time that the force was used. The danger forcing the defendant need
20 more minutes of this.
actual. However, to justify the use of force likely to cause death or great bodily harm, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, the defendant must have actually believed the danger was real. The defendant cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within her power and consistent with her own safety to avoid the danger before resorting to that force. The fact that the defendant was wrongfully attacked cannot justify her use of force likely to cause death or great bodily harm if by retreating she could have avoided the need to use that force. However, the defendant was placed in a position of imminent danger of death or great bodily harm and would have increased her own danger to retreat, then her use of force likely to cause death or great bodily harm was justifiable. If you find that Richard Mallory had a reputation of being violent and a dangerous person, and that his reputation was known to the defendant, you may consider this fact in determining whether the actions of the defendant were those of a reasonable person in dealing with an individual of that reputation.
And now,
In consideration and considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Aileen Wuornos and Richard Mallory.
Remember his ear boy from all that, and then Pizza Face. Dude, all that was hilarious.
If in your consideration of the issues of self-defense, you have a reasonable doubt
Ear
on the question
boy.
whether or not the defendant was justified in the use of force likely to cause death or great bodily harm, you should find the defendant not guilty. However, if from the evidence you were convinced the defendant was not justified in the use of force.
Oh, we are only one name away from a spin. We are right at the edge of a wheel here, so I'm looking for only one donation to get a wheel spun. Ayana, at the very end of the YouTube portion on Feral Friday, dropped $10 through the Cash App, and I appreciate it. I'm also going to do a count just to make sure. Just a Crazy Jen starts this wheel out, actually. 3, 4, 5, 6, 7, 8, 9, 10, 11. So yeah, we are right there to a spin on the wheel this week.
Likely to cause death or great bodily harm, you should find her guilty of all of the elements of the charge that have been proved. Sexual battery is defined as oral, anal, or vaginal penetration by or union with the sex organ of another without that person's consent. Aggravated battery is defined as intentionally touching or striking another, intentionally causing bodily harm, or with the use of a deadly weapon and against that person's will. Aggravated assault is defined as an assault with a deadly weapon without intent to kill or with intent to commit a felony. An assault is an intentional or unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such another person that such violence is imminent. In count 2 of the indictment, the defendant had been charged with the crime of armed robbery. Before you could find the defendant guilty of robbery, the state must prove the following elements beyond a reasonable doubt. 1, that Aileen Wuornos took money and our property from the person or custody of Richard Mallory. 2, that force, violence, assault, or putting in fear was used in the course of the taking. 3, that the property was taken was of some value. And 4, the taking was with the intent to permanently deprive Richard Mallory of his right to the property or any benefit therefrom, or to appropriate the property of Richard Mallory to Aileen Wuornos' home use and the use of any person not entitled thereto. The course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the acts of taking of the property constitute a continuous series of acts or events. In order for taking of property to be robbery, it is not necessary that the person robbed be the actual owner of the property. It is sufficient that the victim has the custody of the property at the time of the offense. The taking must be by the use of force or violence or assault so as to overcome the resistance of the victim, or by putting the victim in fear so that he does not resist. The law does not require that the victim of robbery resist to any particular extent as he offer any actual or physical resistance if the circumstances are such that he is placed in fear of death or great bodily harm if he does resist. Unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be to the person of the victim. It is sufficient if the property taken is under the actual control of the victim, so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. The punishment provided by law for the crime of robbery is greater if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. Therefore, if you find the defendant guilty of robbery, you must then consider whether the state had proved that those aggravating circumstances can reflect this in your verdict. If you find the defendant carried a firearm in the course of committing the robbery, you should find her guilty of robbery with a firearm.
I don't like the ones
If you
that
find the defendant carried a deadly weapon in the course of committing the robbery, you should find her guilty of robbery with a deadly weapon. If you find the defendant carried a weapon and that was not a firearm or a deadly weapon in the course of committing the robbery, you should find her guilty of robbery with a weapon. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find her guilty only of robbery. The firearm is previously been defined for you. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. A weapon is legally defined to be any object that could be used to cause death or inflict serious bodily injury. Attempt is defined as the doing of some act committed or committed the crime of robbery that went beyond just thinking or talking about it, where the defendant would have committed the crime except that someone prevented her from committing it or she failed. A lesser included crime, the definition of robbery, is grand theft. Before you can find the defendant guilty of grand theft, the state must prove the following three elements beyond a reasonable doubt. 1, that Aileen Wuornos knowingly and unlawfully obtained, used, endeavored to obtain, or endeavored to use the property of Richard Mallory. 2, that she did so with intent to either temporarily or permanently deprive Richard Mallory of the right to the property or any benefit from it, or to appropriate the property of Richard Mallory to her own use or to the use of any person not entitled to it. And 3, the property was a motor vehicle. A lesser included crime included in the definition of robbery is petty theft. Before you can find the defendant guilty of theft, the state must prove these elements beyond a reasonable doubt. 1, that Aileen Wuornos knowingly and unlawfully obtained, used, endeavored to obtain, or endeavored to use the money and or property of Richard Mallory. And 2, that she did so with intent either temporarily or permanently deprive Richard Mallory of the right to the property or any benefit from it, or to appropriate the property of Richard Mallory to her own use or to the use of any person not entitled to it. Obtain or uses any manner of taking or exercising control over the property making any unauthorized use.
This is brutal.
Transfer of the property.
When I had to do this in real life and hear the instructions, like I was paying attention, but it is just like, whoa.
Attempt or to try.
It's like
Property
45
means
minutes.
anything of value, it includes real property, including things growing on, affixed to, and found in land.
While he's reading that, I want to see what the next video is.
Property including rights, privileges, interests, and claims, and services. A defense has been asserted in this case is voluntary intoxication by the use of alcohol. The use of alcohol, to the extent it merely arouses passion, diminishes perceptions, releases inhibitions, or clouds reason and judgment, does not excuse the commission of a criminal act. However, where a certain mental state is an essential element of the crime, and a person was so intoxicated,
I'm down for it.
that she
If
was
y'all want it,
incapable of forming that
go to the
mental
verdict.
state,
We still got a lot of videos to
mental
watch.
state does not exist, and therefore the crime could not be committed. As I told you, the premeditated design to kill is an essential element
Putting
of
a
the
poll
crime
up.
of murder in the first degree. Intent is also an essential element of the crime of the first degree, felony murder, murder in the second degree, murder in the third degree, manslaughter, and robbery. Therefore, if you find from the evidence the defendant was so intoxicated from the voluntary use of alcohol as to be incapable of forming the premeditated design to kill and/or the mental states necessary to convict the defendant of first degree felony murder, murder in the second degree, murder in the third degree,
Poll up
manslaughter,
for
robbery, or if you have
skipping
a reasonable
instructions.
doubt about it,
Yes or no?
you should find the defendant not guilty. Aileen Wuornos has entered a plea of not guilty, and this means that you may presume or believe that the defendant is innocent. The presumption states the defendant and each material allegation of the indictment through each stage of the trial until it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the following elements. One, the crime with which the defendant is charged was committed, and two, the defendant is the person who committed the crime. The defendant is not required to prove anything.
So the one no is really a yes.
Whenever the
Got
words
it.
reasonable doubt are used, you must consider the following. A reasonable doubt is
Let's do it. Let's do it. Let's get the hell out of here. All right, verdict. It is kind of silly to listen to that when we know the verdict is what's coming. Like in a real live trial in a state that we may not have watched the trial from, because some of that stuff slightly changes. It makes more sense to listen to the entire thing. It really doesn't here, if we're gonna be honest.
If you arrive at the verdict, is that correct? Mr. Biggs, we received the verdict from the foreman and delivered to the court for inspection from form. Will the defendant hearken to the publication of the verdict? Madam Clerk, will you come forward?
In the Circuit Court, 7th Judicial Circuit, in and for Volusia County, Florida. State of Florida versus Aileen Carol Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Brody, also known as Cammie Marsh Green. Case number
AKA
91-257. Count 1, verdict. We, the jury, find the defendant, Aileen Carol Wuornos, guilty of first-degree premeditated murder and first-degree felony murder of Richard Mallory, as charged in count 1 of the indictment. As to count 2, we, the jury, find the defendant, Aileen Carol Wuornos, guilty of armed robbery of Richard Mallory with a firearm, as charged in the indictment. So say we all.
She's looking over at the jury right now. Look at that look.
Dated at Volusia County, Florida, this 27th day of January, 1992.
Any request from jury before the judge?
We would respectfully request that the jury be called, Your Honor.
Will the jury have clerk?
So, Mrs. Staten, are the verdicts was published, your verdicts?
Where'd that one dude go that was sitting outside? The black dude that was sitting outside the jury.
Mrs. Farrell, are the verdicts was published, your
Maybe he
verdicts?
was the alternate, and they already knew who the alternate was, maybe. Maybe it's a thing if someone gets sick. Maybe it, you know how the shit goes state by state. It really does slightly change, so.
Yes. Mrs. Mills, are the verdicts was published, your verdicts? Yes. Mr. DeGanger, are the verdicts as published your verdicts?
They are.
Ms. Mathis, are the verdicts as published your verdicts?
Yes.
Ms. Walters, are the verdicts as published your verdicts? Yes, they are. Mr. Flowers, are the verdicts as published your verdicts?
Yes, ma'am.
Mrs. Wiley, are the verdicts as published your verdicts?
Yes, they are.
Mrs. Buckland, are the verdicts as published your verdicts? Mr. Watley, are the verdicts as published your verdicts?
Yes.
Mr. Oransky, are the verdicts as published your verdicts?
Yes.
And Mr. Bashaw, are the verdicts as published your verdicts?
Yes.
Thank you.
The representative of the state attorney's office, just one, and the defense counsel report. Ladies and gentlemen, as you have found the defendant guilty as charged with marijuana information, indictment of murder, necessary that a hearing be held for the purpose of making a sentence recommendation to the court. I conferred with counsel in your absence, and we will begin that trial at 1:30 p.m. tomorrow, which time I would request that you report to the courtroom and to proceed with that trial. Counsel also tells me, so that you can arrange your time, they do not expect this phase of the case to last over 2 days. At this time, I remind you once again, if anyone who attempts to converse with you or to discuss this case with you, you're notified the court proper and you will be immediately initiated. If you're not going to time with this or any recess, you will see where your election events may have occurred. You will not read newspaper accounts or review any radio or television broadcast, telecast after the trial. Do not discuss the case among yourselves with any other person. You will not form or express an opinion on this matter for the for your verdict. For the sentencing recommendation. With those instructions, the jury is in recess until 1:30 p.m. tomorrow, and if you'll follow the bed, we will show you.
All right, next video. 18 minutes. Opening statements are heard in the penalty phase. Let's keep going.
Aileen Wuornos, guilty of murder.
So this is the next day.
Punishment for this crime is either death or life in prison without possibility of parole for 25 years. Final decision as to what punishment shall be imposed rests solely with the judge of this court. However, the law requires that you, the jury, render to the court an advisory sentence as to what punishment should be imposed upon the defendant. The state and the defendant may now present evidence relative to the nature of the crime and the character of the defendant. You are instructed that this evidence, when you consider with the evidence that you have already heard, is presented in order that you may determine, first, whether sufficient aggravating circumstances exist that would justify the imposition of the death penalty, and second, whether these mitigating circumstances are sufficient to outweigh the aggravating circumstances, if any. At the conclusion of the taking of the evidence and after argument of counsel, you will be instructed on the factors of aggravation and mitigation that you may consider. Counsel, do you desire to make opening statements, or do you desire to present testimony?
Your Honor, may we have a moment to make a
Yes,
brief
sir.
opening statement?
Yes, sir.
Proceed, Your Honor.
Yes, sir.
Well, we're not at the end of the case, but let me just give you a brief idea of what to expect. I have an opportunity to make an opening statement at this time, as does defense counsel. And His Honor will, after you hear evidence, then give you some more instructions. The penalty phase in Florida is separated from the guilt or innocence phase, and it's usually separated just by the very nature, by a little bit of time. There's a reason for that, and I think it's primarily to give juries an opportunity to settle down and, without passion or prejudice or bias or sympathy or anger, then make a very calm, deliberate, and just decision with regard to punishment without being so close to the time that the guilt or the innocent phase is being decided. Even though your verdict as to penalty is advisory, it carries great weight in Florida. It is very seriously considered by the court. And the law in the state of Florida is such that certainly, and I know you wouldn't, but certainly you should not think, well, it's really up to the judge, it's not too important. It's very, very important. It's what you do or do not recommend. But the final decision and, of course, responsibility is up to the presiding judge in the trial. And, of course, this
is your responsibility to give the maximum. That's essentially, this is very similar.
We know it's Alfred Blunt Jr.
Done a
The
good
verdict
job.
need not be unanimous.
Done the right
All the
job.
verdicts that you returned last night
Follow
by
through.
law are necessarily unanimous. But as to the penalty phase, the verdict need not be unanimous. But a majority must vote to recommend the death sentence, if in fact that is to be the recommendation. In other words, it would take a minimum of 7 jurors to vote in favor of or supportive of the death penalty.
We didn't have
before that would be
death.
the
We had life with possibility without parole, which is what we gave him. We gave him the max in our trial.
recommendation. If it was a 6-6 split, then the recommendation is for life imprisonment. The aggravating and mitigating factors have been established by statute, so you're not going to be left to try to figure out what is or isn't to be considered in the first place. Will not be presenting anything that's not lawful. Judge Blunt will see to that if we're not able to do that on our own training. He's here to make sure you only receive lawful evidence. And your decision really will be to decide whether or not the aggravating factors would justify the imposition of the death sentence, or whether there are such mitigating factors presented, if they are presented, which would outweigh the aggravating factors and therefore justify life.
Objection, Your Honor.
The burden with regard to proof is still on the state. It must be beyond a reasonable doubt. And the defense, I believe at this point, still has virtually no burden. We have the burden. Most of the aggravating factors that we would present have already been proven in the trial. And tell you that to let you understand two things. One, yes, you not only may, but you should consider the evidence you've heard up to this point. That's part of the state's evidence with regard to the aggravating factors. In fact, it is the majority of that evidence. You will hear some additional evidence, but we will not go back and present the whole case again at all. One, that's not permissible, and number two, certainly it's not necessary. You've already heard it. So what you've heard in trial to this date should be considered as you determine the aggravating factors. The aggravating factors that the state intends to prove, which we believe will justify and do justify a recommendation that Ms. Wuornos receive the sentence of death, are as follows. One, that she has previously been convicted of another felony, separate from the ones here, involving the use of violence or the threat of violence against another person. Number two, that this particular conviction, murder in the first degree, which your verdict confirmed and in fact was the final arbiter last night, that it was committed while in the act of carrying out a robbery. And of course your verdict confirms that already. You've already made that decision.
Objection, Your Honor. Thank you, sorry, Mr. Tanner.
And next, that the murder was committed to avoid or prevent, in effect, Ms. Wuornos' arrest. And that was already presented to you, Deputy Gorzepa's testimony, and almost 2 weeks ago now. With regard to witness elimination. And she, on the witness stand herself, told you that she felt no one would believe her. He took her story in its best context, and therefore she decided to kill him so he couldn't tell on her. That is, in fact, killing someone to avoid being arrested and held responsible for your acts. Next, that the felony robbery, the murder, was carried out for the purpose of obtaining financial gain. There's been overwhelming evidence of that. the selling of the property and of the keeping of the property. And finally, that the murder was committed in a cold and calculated and premeditated manner without any pretense of moral or legal justification. Again, I would respectfully say that your verdict has confirmed that this was a premeditated murder, and that her, certainly from the time she fired the initial shots, if premeditation was not firmly established before she did, we contend that it was. That's why she had the pistol. But in any event, certainly as the succeeding shots were delivered and ultimately as she went around and confronted Mr. Mallory and shot him virtually to death, that amply supports the aggravating factors of cold, calculated, and premeditated.
With all due respect, Mr. Tanner, objection, Your Honor, heightened premeditation.
Overruled.
Overruled. You already fucked.
Don't be led astray as you listen to
This judge
evidence.
sucks, dude. Worst judge we've seen on Murder Church. By
We need
far.
not prove
That's-
every possible aggravating factor recognizable under the law. There are many recognizable under the law, such as that the murderer was under another sentence at the time they committed the crime, or it was meant to disrupt government, or that a government official was killed in the performance of his duties, or a police officer in the performance of his duties. Or even the particular aspect of requiring particularly heinous, cruel, or atrocious torture-type murder. The state doesn't have to prove that to justify and to seek and to obtain a recommendation of the death sentence. Those are just some other aggravating factors that appear in some cases. They don't appear in this case. And we're not asking you to consider those as aggravating factors. You will hear perhaps other evidence of mitigating factors. Don't believe that this is simply a balancing test as to how many versus how many. You may give such weight as you see to each aggravating factor, or such weight as you see, or lack of weight, to each mitigating factor. And if even one aggravating factor would, in your opinion, the majority of you justify the imposition of the death sentence, and that is sufficient. We believe that the evidence that we will present over the next day and a half will convince you that the sentence that is appropriate in this case, the sentence that would do justice, and the sentence which is justified by the evidence, is a sentence that Aileen Wuornos paid with her life for the crime she committed in murder of Mr. Mallory. Thank you.
Ms. Ellis, you better make a note of things you reserve on the statement.
Your Honor, we would prefer to make it at this time.
Sir.
Mr. Tanner, Mr. Miller, Ms. Jenkins, Your Honor, ladies and gentlemen of the jury, good afternoon. You've heard 2 weeks of state's evidence regarding Ms. Wuornos' guilt. You've seen Lee Wuornos testify from the stand. You saw her cross-examination. You observed her demeanor. You've seen her here in court. And some of you must have observed her behavior here in court during the course of the last 2 weeks. And I dare say that many of you must have been thinking to yourselves, why? Why is this? Why is Lee the way she is? This is the part of the case where you get answers to the question of why. Mr. Tanner talked to you a little bit about aggravating and mitigating factors. His Honor will instruct you at the end of the case that any aspect, anything regarding the accused, which you as a juror believe to be a mitigating factor, is sufficient to warrant a vote that Lee Wuornos not be sent to her death, but that she be sentenced to life imprisonment. Mitigating factors, as His Honor will instruct you, are not limited. And they are reasons why you as a juror can say, for this reason, I will vote to spare her life. People do not simply fall from the sky. Lee Wuornos did not simply fall from the sky. Her biological father, the evidence which you will hear will indicate to you, was a person who hanged himself in a penitentiary where he had been convicted of kidnapping. The biological mother abandoned her before she saw her first birthday. Lee Wuornos did not simply fall from the sky. There are biological, genetic, and environmental factors that make each and every one of us what we are. And there are such factors here. And they make Lee Wuornos what she is. And when you hear those factors, those mitigating factors, factors that our law has as the embodiment of the compassion, the mercy, and the justice that we as a people hold dear, we are going to stand before you and ask you not to impose a sentence of death on this woman. Lee Wuornos, you will hear from the evidence that will be presented from the time she was a little kid, 6, 7, 8 years old. Her school records consistently reflected this is a person who is impaired. This is a person who is not well. This is a person who needs help. She never got that help. She was raised by her grandfather, a person who you will hear evidence on, drank. He was an alcoholic. He was a drunkard. And you will hear evidence about his being abusive. Lee's grandmother, the person who Lee believed to be her mother up until her teenage years, is a person who Lee described as a heavenly angel. She feels for her. She loves her. She's not deceased. She loved her. And this heavenly angel was a person who was meek and humble, and a person who could not intervene when Lee needed help. A person who could not deal with the dysfunctional family in which Lee was raised. You will hear evidence during the course of this proceeding answering that question, why, about a fire in which Lee was burned when she was a young child, and about the problems with her self-image resulting from that fire. During this proceeding, you will learn about the fact that Lee was raped when she was 14 years old, and I know that's a word that's been used during the last 2 weeks. She was sexually abused and raped by a gentleman in his 40s, and she became pregnant. And she was so terrified of what her family would think of her that she tried to hide the pregnancy. And eventually nature took its course, and the pregnancy could not be hidden, and the grandfather found out, and he was ashamed. And he sent her to an unwed mother's home. And there she had the child, a child she never knew, a child that was taken away from her. People don't fall from the sky. Lee Wuornos did not fall from the sky. There are things that she was born with, and things that affected her as she grew up, and things that mitigated in this case. At the age of 15, Lee was put out of her home. She had no skills. You will hear about her school records. You will hear about the fact that she had no skills. She hitchhiked from place to place, and she did, in order to make a living, the one thing that apparently she could do. She sold her body. You will hear about the fact that she was abused physically and sexually on a number of occasions while hitchhiking, while trying to make a living by selling her body. You will hear that she became an alcoholic. And you will hear that as she grew older, things got worse. You will hear about a young man that Lee loved very much, who left her. And because she left her, Lee got herself a gun and shot herself in the stomach, trying to kill herself. And you will hear evidence about Lee's impairments, about what the genetic and the biological factors, and about what this environment has done to Lee. You will hear about why she is sitting before you today with this demeanor when you will be deciding whether she lives or dies. You will hear that for Lee, the world is a very strange place. It is a hostile, it is a frightening, it is a bitter place. She doesn't see the world the way you and I see it. She doesn't understand the world the way you and I understand it. She cannot function in it the way you and I function in it. You will hear about her cortical impairments,
Give her the right to
her
murder
inability
anybody.
to control her impulses, her inability to reason, her disturbances, her impairments, her inability to cope with the world around her. It is to her a hostile, frightening place. And the way she reacts, because it is a hostile, frightening place, is a way that we see as inappropriate. His Honor will instruct you on mitigating factors. You as jurors, when you consider mitigating factors, you have a very hard job. You have to look at the world, only for a moment, through the eyes of somebody who is impaired, who is not like you and I. And you have to see the world through those eyes. You have to see the frightening, persecutory world in which Lee Wuornos has lived and now lives.
Kind of, right?
A world in which she has no solace. A world in which she has
she's
no
not like
place.
you.
And yet a world which has made her what she is, in which counsels you as a jury to say, yes, I understand mitigating factors. I understand what they are. I understand there are reasons why I should spare a life. And when someone is this impaired, when someone's deficits are so great, I will say life in prison. I will not vote to take that life.
We're going next year. We're going next to some testimony here. Yeah, the very first season we ever did here was Dahmer's, and Dahmer's was a different type of trial. It was interesting. It was to see if Dahmer, like he'd already admitted to killing all these people. It was to see if he was going to be going to a mental institution or going to prison. It was a very interesting trial. So it wasn't really about a guilty verdict because we already knew that he was guilty of the crimes that he committed. We just needed to see if he was in his right mind when he did it. And it's very fun to watch. It's very interesting. It's very emotional. The very ending of it, I had to take myself off screen because the victim testimonies was absolutely earth-shattering. And I know you guys have seen the scenes of those just, through media. But yeah, Dahmer's is very interesting. There's a playlist of all the past murder churches. Dr. Kevorkian, I did that one with Bob Motta. Me and Bob Motta every Sunday morning did that one. Dahmer was the first season. We did this crazy-ass fucking college student out of Tennessee that hacked his parents up, and the cops came in while his mom's head was on the stove. I forget that guy's name. He was crazy. And then season 4 was fucking Spectre, which lasted over a year. And then of course the Adelsons, and now this. Yeah, this is season 6 right here. Aileen Wuornos. But yeah, we'll start this one next week. I'm gonna be listening to some testimony for some people who either think she should get the death penalty or shouldn't get the death penalty at this point because she has been convicted. We'll start out with Detective Lawrence Horzepa. I believe that is who, if I remember correctly, it says latent print examiner. Oh, no, okay, so Dr. Lawrence Horzepa, I believe, is who did the original confession audio. And we're also going to see a latent, probably butchering this word here, I know, print examiner Jeannie Ahern and corrections officer Susan Hansen. And yeah, we're getting very close to the end of this. Oh yeah, Joel Guy Jr. was the crazy guy name. The guy's name, and that one is crazy. If you go and watch that trial, holy shit! It's the shortest opening statement ever. His lawyer is basically just like, I don't know what we're doing. Clearly had a court-appointed lawyer. Also, he was horrible. Not that you could. This guy was caught red-handed. He had a journal that he had left inside the place that did step by step of what he was going to do to his parents. He wanted to get money, a big inheritance. That one is fucking stupid. What an idiot, dude. Joel Guy Jr. That one is nuts. So yeah, go back and watch Dahmer. That was the very first one ever. Almost 2 years ago now, which is insane. Yeah, the Dr. Kevorkian was crazy. That one was very interesting because I'm a huge fan of Dr. Kevorkian myself. And I think he's a beautiful, beautiful person, a beautiful man. And yeah, that one will get you absolutely emotional as fuck. Watch that one with Bob Motta every week. That was really cool. But yeah, this has been fun. Tonight we're going to be live again 6 Eastern. I'll be back here watching some wrestling on Wrestle Plunge. This stream will take you directly into tonight's show. So when you get over there, if you wouldn't mind hitting a like, that'll help me out. other than that, I will see you guys Tuesday. Of course, book club will be Tuesday night. We're getting closer and closer to finishing up. I think we got about 7 hours left of Mindhunter. Every Tuesday night after the regular show, we go into a members only and we listen to a chapter through Audible, the entire chapter, and it's super duper fun. And anybody that's a member has access to all of the past content, of course. Yeah, lots of cool stuff. You too, Ember. Thanks for coming through here. I can't believe you have great weather. I'll be trapped here, which I'm fine with. I've got lots of food. I've got some entertainment. I've got some probably nothings. I think it'll be good. I'm wondering if I'm going to be going to work tomorrow. Which, if it doesn't get any crazier, I will be. But we'll see, I guess. We'll see. We'll see. Everybody stay warm. Again, thank you all so much. Love you guys. Let's do it. Boom.